Now it's been a few months probably since I infamously go on camera and I said, "Fines Victoria, you are unlawful." The trial is going to be November. That Fines Victoria had removed their licence suspension. One of the specific reasons why Fines Victoria pulled out before getting us pregnant so quickly, right? When we lodged that injunction to say, all right, Fines Victoria, you can't do what you're doing. Fines Victoria is not a court for the purposes of Chapter 3. This is the Boilermakers doctrine, and it's also been reiterated pretty recently in Burns v. Corbett. So it says is, okay, they're not a court, and specifically to adjudicate on a constitutional matter, which is because the fine that this woman got was for protesting, and the defence to the fine is constitutional. It's to say, just like Brown v Tasmania, we can protest. Saying to Fines Victoria, you're not a court, you can't determine whether the state has unlawfully breached that constitutional right. You can't do that. Only a court can. And that's the origin of the fine. Was it was a $5,000 fine that this woman was given, and that on the basis then for them to remove the licence was that $5,000 fine. Now, Fines Victoria, not paying attention to any of this, was like, well, we've just got, because they're a collections agency, right? That's what they are. They are a collections agency that's been delegated that authority through the Fines Reform Act in Victoria. And they were just like, well, it's a $5,000 fine. Doesn't matter how or who or what. When we have a $5,000 fine that's been sitting there for a while, now we issue our directions, like sending out the sheriff for them to remove property, to put liens on you, to suspend your license, to clamp your car, to do all these sorts of things. Right? They've been delegated that authority, and that they can legitimately do these things because they clearly are not a court. They can't determine a constitutional matter. Because the broader picture to Fines Victoria is clearly speeding fines, traffic fines, fines from council, and all these other, because they are a collections agency, and you can read in the Fines Reform Act that they collect fines from all these diverse areas of law and administration. With regards to Fines Victoria, what we've got going, I've got someone who's drafting up a section to the website that's going to be able to take your statement of claim. That is, everyone who's watching who's got a fine. That's just about everyone. Everyone who's watching. There's going to be thousands of people who join. Now, I'm just doing my, due diligence to find out how to submit that matter in the Supreme Court to get a class action running, and to for it to be as simple as possible. Is that everyone's going to need to sign, get witnessed an affidavit saying, here's my statement of fact, to say, I was issued a fine on whatever date, speeding, whether it's some other traffic incident, or whether it's to do with protesting, because there's a few of those too, and that affidavit will then reference documents like where you upload basically your exhibit. So that is your fine, your actual fine. And so I just want to have that running in the background. Let's have a look at this question from Tobias. In Canberra, the ACT, they're issuing infringement notice. Is this the same in Victoria? It's cases like Kable versus DPP, 1996. It's in the High Court. Or you can look at Totani versus South Australia. These are cases that they are illustrating via whatever matter they were. In the case of Kable, he was in prison for manslaughter, and they were trying to detain him outside of his court order to be inside the prison, and so they talked about this, and they said, well, the judicial process, right, the rule of law says that if you have broken the law, even if it's just statute law, as in, it's not like you've committed an act of violence, for example, right? So even when you've just broken the statute and there's no harm per se, still, when you've broken the law of any kind, the judicial process, they have to summons you, right? So if you are speeding, an infringement notice or a penalty, these can only be issued by a court, and they can only be issued by a court when you've been proven beyond a reasonable doubt that you are guilty of some offence. Now, I'm not saying that all of us out here haven't been speeding to the letter of the law. Our point, once again, is that if the judicial process was followed every single time, think about that. Right? And this is what I said in my last video and the video before that, that if everyone who was speeding, everyone was flashed, right, going through a red light or doing 65 in the 60 zone, whatever it is, if they were all given a summons and summons to court, the court would be filled, right? It would be absolutely filled. It would be round the corner, right? Even if you are guilty, right? Even if, prospectively, like thinking about it, you are guilty of that crime, right? You have infringed, right? You have done what they are saying you have done, right? There would be lines around the corner. Lines around the corner. And then what would happen, Tobias? What would happen? Because they wouldn't be, like, there's only so many magistrates, right? There's only so many judges. What would they have to do? If they couldn't physically hear, and there are thousands of fines given every day, thousands of infringement notices given every day. And what do they say to you? Oh, well, you can pay the fine, or you can have an internal review, or you can go to court. No, the judicial process doesn't work like that. There cannot be an option. There can't be an option for you to like, think about, like, if this was murder, right, or assault. Do they say to you, well, you can just pay a fine, then you don't have to worry about going to court? No. Right? No, they don't say that. So what I'm alluding to again is the judicial process. And if there were lines around the corner because every single person who had been, there was an allegation against them, that the court would be full, and the court would not be able to determine the matter. And then what would they do? Well, the judges would go, well, we have a problem. What we're going to do, and this is in theory, right? You can think for yourselves. If there were thousands of matters and one judge sitting there in courtroom 14, and it's the same in courtroom 13, 12, 11, right? If the same in every single court, that you had lines around the corner, and the judge is like, on my docket today is 106 cases, right? And 95 of them have got to do with speeding, right? What would they do? Because they can only physically hear how many cases in a day. What they'd say is, well, we're going to have to prioritize. Go back to, I think that video of Packer in the Senate, right, where he's going, we're a nanny state, right? We've created so many laws, right? And this is what's happened, right, is that it is easier and easier to break the law every day, because they're passing through more and more legislation. And what did Packer say? Well, he's like, well, I don't think we live in a better Australia now because of all of this new legislation. He says if it was him, he would have had a rule saying, for every new piece of legislation, we're going to remove an old one, right? Like for like, or something to that effect. And even then, I'm not sure. I think we're beyond that point. Like, we just can't stop creating more legislation. And what happens when you create more legislation? Well, it's easier to break the law, and then it's easier for it to end up in court. And what happens if you can't, if the system can't actually physically hold all of those matters? Well, I'll tell you what happens. Right? In the Magistrates Court Act itself, they are delegating authority to Fines Victoria and the Fines Reform Act for expediency. They're saying, we want to lighten the load, right? We want to lighten the load on the Magistrates Court. And so in our own act, we're going to delegate justice to be heard somewhere else. But why? Because of what Packer was saying. We have got so many new laws, and every year it's more and more and more and more, right? And it's easier to break the law. And it's because this is the thing that we're all railing against, that if there's no harm, then where is the crime, right? And that's the point. We are moving further and further and further away from that, because that's what a civilized society does. And so back to this proposition that what Fines Victoria has done, and it is the same in every state, right? Revenue New South Wales is doing the same, and it is so ingrained. It precedes federation. It precedes our constitution. The rule of law is what we base. It's what we base. such provisions on. Right? It's an old concept that probably goes back even to the Magna Carta, although not so much. Because they did like to chop people's heads off, and I'd say that's a violation of your natural rights.